we're going to have a hearing. The case law provides that a hearing should be conducted to determine whether a witness's exclusion from the rule of sequestration for witnesses will result in prejudice to the accused. Mr. O'Mara?
Well, Your Honor, as I mentioned earlier, I thought it might be appropriate to have a relaxation of the rules on both sides, but primarily from my client. The purpose of the rule of sequestration obviously is to make certain that the witness's testimony is not affected by their ability to listen and hear the evidence they're going to hear today before their testimony. In this case, having had the enormous amount of publicity and the enormous amount of information flow that has gone back and forth, I would suggest to the court that any further, quote, infection of any witness, be it my client's family members or any other, is quite honestly minimized. So that's one suggestion I would offer to the court. The second one is that the evidence that, or the testimony that might be infected or affected by listening to other witnesses needs to be something substantive, something that I would suggest is of relevance to the court. To that extent, I would ask if there is such a presentation that can be made, if in fact the state intends to call Mrs. Zimmerman and Mr. Zimmerman, or if maybe this is just on a witness list for the purpose of keeping them out of the courtroom. And to the extent that that exists, and my client's right to a fair trial, we have to date been very cautious about how we present both sides to the jury. Of course, we've had some concerns with certain members of the church and where they may be seated in the courtroom. We've been very careful with...
Can we please stay on focus? Because the rule does not give me... The rule does not indicate at all that any other witnesses on a witness list are allowed in the courtroom except for the victim or the next of kin, the parent of a minor child, or a lawful representative of such person. Does not provide for any other witness. There is some case law that talks about experts, mental health experts, and the court has the discretion whether to allow them to remain. There's nothing in there that says family members of the defendant, even if they're on the witness list, are entitled to be in the courtroom. The test is if there's prejudice to the defendant for, at this point in time, whether or not the victim's parents are allowed to remain in the courtroom or their representative. I know that you had objected to Mr. Crump. A court will find, as to that part of it, and I've read the case law over lunch, and in conjunction with the rule says, or a representative. If the family members are going to be in here, then they don't need a representative. So to the extent that the family members will be present during the trial, as long as Mr. Crump is going to be remaining on a witness list, he will not be allowed in the courtroom pursuant to the rules of sequestration. And as far as the victim's parents or next of kin, they are allowed in. The defense has to show some prejudice to keep them out. So I'm wanting to conduct a hearing now on what prejudice would there be to the defendant if they were allowed to stay in the courtroom.
I do not make such an argument as Ms. Fulton or Mr. Martin.
Well, but that's what the case law says. The case law says that the defendant has to first show that will object to their being in there, and then make a showing that there's some prejudice. If there's no showing of any prejudice, then they do stay in. The court would have to weigh what the prejudice is and the rights of the defendant. And there's other safeguards that are put in place based upon the case law. For instance, if the family witnesses have been deposed, then that's a safeguard for them staying in. So if you're saying that there's no prejudice to the defendant for Ms. Fulton and Mr. Martin to be in the courtroom, then that's not an issue.
Mr. Martin presents a more unique situation since, as I mentioned at the bench, Mr. Martin, in fact, threatened or at least cursed at one of my client's family members who was sitting there with a
What is the prejudice? Please don't go off focus here.
No,
me either. Okay. You need to show me what prejudice to Mr. Zimmerman's right to a fair trial would result if Mr. Martin or Ms. Fulton remained in the courtroom as the next of kin and parent of Trayvon Martin. And whatever you want to present to the court, I will hear the testimony and conduct that hearing.
I will need to get the witness available, not present now, but that witness will testify that Mr. Martin cursed at him as a family member, and if he cannot abide by the rules of this court and appropriately conduct himself, then he waives the right to be here as a victim's family member when the mother is here already. So that's my concern if we're talking about Mr. Martin himself. And I'd like some time to get the witness back so we can have him testify to you. But as a proffer of that testimony, that is what happened in your courtroom.
In the courtroom?
Yes.
Because the court has observed, today is a full house, before then it was not, and I have had the opportunity to observe the family members, friends, press, everybody, and from this court's point of view, other than a few cell phones going off, everybody has been very well behaved, and I have not observed any outbursts, any emotional comments, or any going back and forth. And if that happened, it would have happened when court was in recess. It didn't happen during the time that the court was here. And I will particularly admonish anybody in the courtroom, whether they be a family member, a friend, or a member of the press, that they are not to have any emotional outbursts or any contact with any of the potential witnesses, family members, or anybody else while they're here in the courtroom. So is there any other thing that would be a prejudice?
No, Your Honor. My other argument is that I would like the state to present whether or not they do intend to call my client's mother and father, or if it is literally a facade to keep them under the Rule 9616 and out of the courtroom to offer a more balanced perspective as to my client's family members who wish to support him.
Do you really want me to do that? Because then the state's going to ask you what you intend to do with all of your witnesses.
I'm not trying to. My concern is two witnesses, my client's mother and my client's father.
Well, that's a matter that I'm not going to require the state to do on the record, but you're free to have a conversation with the state about that, and if it's something you can come to an agreement to, I will, let you stipulate to that. But to try to get into what either side intends to do with any of their witnesses,
a fair
I'm not
trial
gonna
is
go
to
there.
be afforded to my client, and that fair trial is a way to present to this jury an appropriate setting. The setting in this courtroom has now been lopsided in favor of the state through the victim's family.
Then what are you suggesting, Mr. O'Mara, that I have every member of the public who may have an opinion one way or another be removed from the courtroom? I don't know.
Mom and Dad, both sides. That seems fair to me when I look at it and say, what is fair to this jury?
The Supreme Court and the legislature, the Supreme Court has determined that a victim's family has an absolute right to be in this courtroom.
That's correct. And I understand that it doesn't say defendant's family, but that you do have the discretion to do so if you'd like.
If they weren't on the witness list, they would be free to be here. If once they're called and they've testified, they're free to remain in the courtroom. Okay. Anything else on this matter?
I might just have one moment.
Yes, you may. Just for the record, the cases that the court had considered was Gore versus State, 599 Southern 2nd, 978, Supreme Court, 1992. Cain, C-A-I-N versus State, 758 Southern 2nd, 1257, 4th DCA, 2000. And Beasley, B-E-A-S-L-E-Y versus State, 774 Southern 2nd, 649, Florida Supreme Court, 2000. Okay, was there anything else?
Mr. Jakolski is in the courtroom, so I would call him to the witness stand as to the issue. I thought that he had left because of that occurrence, but he is.
Okay, Mr. Jakolski, where are you? Please come up here, raise your right hand to be sworn.
Do solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please come up, take the stand. If we could please get the easel down and... Thank you.
May I inquire?
Yes, you may.
Sir, state your name, please.
Tim Daholsky or Timothy Daholsky.
And if you would spell your last name.
Tucholski.
And you've heard me mention to the court sort of what I call proffering information, because I didn't know that you were right behind me, concerning an event between yourself and a member of the Martin family.
Yes.
If you could narrate and just tell us what happened and where and when.
I was coming back from a restroom break. I had taken myself. I believe the court was still in session when I came in. When I was walking, it was just being let out for a break. And Mr. Martin had...
Can you point out the person who you identify as Mr. Martin?
Right there in the blue suit.
Is that a light blue suit?
Light blue.
Thank you.
Had seen me and seen my badge, saying, look, I guess looked at the chest, and right here he looked down where this was and said, motherfucker, under his breath.
Loud
Enough for me to hear it.
Did you respond in any way?
No, sir.
Did he say anything else?
No, sir.
He was in the courtroom when that happened?
Walking outside the door. I was holding the door actually for him and Mrs. Martin and some other
Was
people.
the judge on the bench?
To be honest, I don't know, sir.
Nothing further, Your Honor.
Thank you, Andy Cross.
There's one of them.
Yes, you may.
How are you related to the Zimmerman family, sir?
I'm a friend, Mr. Zimmerman.
And was this your first time in court?
No, I've been in courts the last 2 Tuesdays.
Okay, so you pick on Tuesdays to be in court only? Is that the last 2 Tuesdays?
Yeah, it's the only time I could get off work to support.
Sure, okay. And on the 2 prior Tuesdays, did any other family member say anything to you?
No, sir.
Okay. And well, you're telling us that Mr. Martin, Tracy Martin, all of a sudden, just under his breath, used the word, the language you used, the profanity you used, MF?
Yes, sir, that's what I believe I heard.
It's what you believe you heard, so you're not sure you heard that?
I heard it under his breath.
Well, are you sure or are you not?
I'm sure that's what I heard.
And what other words did he utter?
That's it.
So you were being nice enough to hold the door for him.
I was walking in while he was walking out.
Right, and so you held the door for him, and he looked at you, stared at you, and said, pardon my language, motherfucker, under his
He
breath?
never said part of my language.
No, that's me saying it. Excuse me. I don't use profanity.
Well, I was walking in, and it was real quick. Like I said, it was under his breath, and it was that word.
So if that occurred, wouldn't he have been concerned that you maybe were going to smash the door in him? Wouldn't it have been concerned that he would be getting out?
I don't know what he's concerned with.
I object. He's badgering the witness. It's a simple statement. Now he's coming up with some fantastical thing that Mr. Martin would think he was going to get the door smashed in his face, and that's what I said.
Okay, so let's stop this right now. I have told counsel before, first of all, no one talks over the other. The court reporter could only take one person down at a time. I will not have any speaking objections in the courtroom. What is your legal objection?
He's harassing the witness.
Okay, overruled.
Demonstrate to me exactly what you're saying. You were coming into the courtroom, right? And so we're talking about this door right here or the outer door?
The outer door.
Okay, so nobody else saw it except you?
Well, yeah, it was, like I
Right?
said, he was right in front of me here,
Okay.
and I heard,
Right.
I saw him look at me,
Right.
and that's the first time I ever made contact with anybody.
Right. But
on
you're
that side.
saying, so this did not happen actually in the courtroom, it happened outside the courtroom?
It happened between that door and the other door. It was a big crowd of people coming through. I guess it was a break, so a lot of people were coming through. I was coming back.
And you opened the door for him to let him out?
I didn't open the door specifically for him. I was already coming in. I was holding the door because there was a lot of people coming towards me. He was one of the people coming out.
And he went right by you and looking straight ahead, right? He all of a sudden turned towards you.
No, he was, like I said, he was in front of me. He looked down. He was in front of me, coming towards me, looked down at my badge, or my chest area, I'm assuming
Sure.
the badge, and that's when I heard it. Again,
Okay.
that's
So
it.
when he uttered these words, he was not facing you, but he was looking down, correct?
He was looking down. I saw him look at the badge. I can't remember specifics because exactly what happened was, from my view, was he looked down at my chest area and he said that word. That's what I thought I heard.
That's what you thought, so you're assuming that, right?
That's what I heard, and because that's what my ears heard, I'm assuming yes.
Okay, so, but you're saying that Mr. Martin was looking down at and reading your name, and in the process of reading the name on there, George Zimmerman.
As I said, he looked down. He wasn't staring the whole time as you're trying to, he wasn't staring at me directly in my eyes. He wasn't staring directly down. He glanced, he looked, he said the word, and walked past. And that's all I can tell you.
And there wasn't a threat, was there?
No.
Okay,
That's
so
what
when
I
Mr.
heard.
O'Mara earlier said there was a threat, did you lie to Mr. O'Mara about that?
I never said there was a threat. That's what my specific word, that was the word I heard.
Well, why would Mr. O'Mara have uttered to the court and asserted that there was a threat?
I don't know. I never said threat.
Who did you tell this first to?
I told originally to Shelley Zimmerman.
To Shelley Zimmerman? And she was in the courtroom at the time?
She was sitting in the courtroom, yes.
So this happened before the court got started, before we had the hearing about who could be in the courtroom or not?
Yes, that wasn't today.
So this didn't actually happen today, it happened a prior day.
Yes.
And now you're bringing it to the court's attention?
Only because I'm being asked to.
Okay, so I
didn't-
misunderstood. I thought you said it happened today.
I never said anything like that.
I completely apologize. My fault that I assumed. So it happened last Tuesday?
I believe it was, I can't remember, it was either last Tuesday or the Tuesday before. I think it was the Tuesday before.
So maybe 2 weeks ago, and you waited all this time?
I never waited. I actually told somebody. I didn't want to make a big deal of it because I didn't seem like I should pile anything on to either side right now. So
All right.
I didn't say anything. I was asked,
Sure,
and
okay.
then, so I said something.
Okay. And so 2 weeks ago, or maybe later, even longer than that?
No, it's only the last 2 weeks.
Okay, and you told who now?
I told Shelley.
You tell Ms. Zimmerman, Shelley
Right,
Zimmerman?
right.
What? Did you tell anybody else?
After it happened, and I didn't think it was as, big of a deal. Not that it wasn't a big deal, I just didn't want to make any ripples. I didn't want to make anybody sound bad or...
Sure.
So after I told them, I guess they said it might have been a security issue, so I believe some of the deputies were told that it may have happened, or...
Did you go and tell the
I didn't tell
deputy right
anybody
away?
else, no. I discussed it with
Shelley
Shelley and...
Zimmerman?
Yeah.
Okay. And so you don't know how Mr. O'Mara found out? I
I'm
guess.
sure, I'm assuming through
Okay.
Shelley.
And of course, you're telling us the truth now, right?
Absolutely.
Okay. But it wasn't that important 2 weeks ago, and now it's when you bring it when there's this
Because
hearing about who's...
like I said, I've been asked to. I wasn't planning on coming up here. I don't want to be
Okay.
sitting here.
Okay. Thank you very much, sir.
Okay.
Thank you. Any other questions?
Justin, what is the name, what's on your badge?
It says family Zimmerman, and then a number and then the date.
Okay, thank you. You may go ahead and take your seat. Are there any other witnesses from the defense?
I can call security concerning it, but they found out and instituted a policy that people have
Okay,
to
my
have.
question is, are there any other witnesses?
I don't think we
Okay.
need to know that.
The court's ruling is going to stand, and I'm going to cite again the case of the state of Beasley versus State of Florida, citation previously given, which states there are two bases upon which a defendant may object to the trial court's decision not to apply the rule of sequestration to a witness who is the victim's next of kin. First, one could argue that the witness has changed key testimony to conform to the evidence presented, and counsel had indicated that that was not a concern, and the court has asked if depositions of the next of kin or the family members have been taken, and the answer was yes. The second area of concern may be the prejudice potentially caused by emotional reactions of the victim's family members, and again, the court has stated that there have been no such emotional reactions from the victim's family members while this court was in session for this court to observe. I do not find the testimony that we just heard to be of any concern to the court, but especially with the court admonishing everybody, as I have, that there'll be no emotional outbursts and no comments to other people. With that ruling, with that determination, the court rules that Ms. Fulton and Mr. Martin may remain in the courtroom. While they're here, Mr. Crump will not. As long as Mr. and Mrs. Zimmerman remain on the witness list, they will not be allowed in the courtroom until they have completed their testimony or otherwise been released. Do you need a few minutes before the state calls its next witness?
We need to change out the laptop and I think the lectern.
Or calls her first witness, I should say. Yes, let's go ahead and get the court ready. How long do you need?
No more than 5 minutes.
Okay, court will be in recess for 10, to make sure we have enough time.